Before learning about Grutter v. Bollinger, it would be well of you to learn several terms. These terms are displayed on the screen. These are quite important when studying this case. If you need to read them, just pause the video. Before getting into Grutter v. Bollinger, I should probably mention the Bakke decision. In it, a 33-year-old white man named Alan Bakke was rejected from UC Davis's medical school. UC Davis is a state school and is therefore subject to the 14th Amendment and Title VI in the 1964 Civil Rights Act. Bakke then sued the school for discrimination by race. Justice Lewis Powell, writing for the majority, ordered his admittance and struck down UC Davis's quota system, which set aside 16 seats in each class for minorities. However, Justice Powell did note that there was a compelling governmental interest in having racial diversity. Powell spoke favorably of Harvard's affirmative action program, which did not have a quota system, but rather considered race in addition to other non-academic factors. Now on to the case of Grutter v. Bollinger. The plaintiff, Barbara Grutter, graduated from Michigan State with a 3.81 GPA and a score of 161 on her LSAT. However, she put off law school until she was 43 in order to work in the healthcare industry. She applied to UMichigan Law School, where she was waitlisted and eventually rejected. She sued the University of Michigan for discriminating against her through their affirmative action system, citing the Equal Protection Clause and Title VI of the 1964 Civil Rights Act. The defendant, Lee Bollinger, was selected because of his status as the then president of the University of Michigan. The University of Michigan Law School used race in consideration for admissions in order to acquire a critical mass of minorities, which yielded three specific benefits. One, it ensured that minorities did not feel exposed to for their race. Two, it increased the number of opportunities for the benefits of diversity to come through fruition. And three, it ensured that minorities could dispel racial stereotypes. Kirk Colbo argued the case for Grutter. Colbo also argued for Gratz in the Gratz v. Bollinger sister case. He is currently a partner at the Maslin, Edelman, Borman, and Brand law firm. Maureen E. Mahoney argued the case for Bollinger. She served as Deputy Solicitor General from 1991 to 1993 and has argued 20 cases before the Supreme Court. She works at the law partnership Latham-Watkins. District Court Judge Bernard A. Friedman from the Eastern District of Michigan ruled that the law school system was indeed unconstitutional because it is, quote, practically indistinguishable from a quota system. The Sixth Circuit Court of Appeals overturned Friedman, noting that the Bakke decision was binding precedent. The Supreme Court granted certiorari in order to decide whether the diversity is a compelling interest that can justify the narrowly tailored use of race in selecting applicants for admission to public universities. There were a total of 6 opinions, the breakdown of which you can see here. In the interest of time, I'm going to focus on Justice O'Connor's opinion of the court and Justice Rehnquist's dissenting opinion, although all of them are worth discussing. Justice O'Connor, writing for a majority, declares that UMichigan Law School's admissions system passes the test of strict scrutiny. While some allege that there is only a compelling governmental interest to remedy past discrimination, O'Connor notes that the law school has a compelling interest in attaining a diverse student body. O'Connor also alleges that the law school's admissions program bears the hallmarks of a narrowly tailored plan. It meets this requirement by allowing each applicant to receive individualized consideration, a strike against the quota is deemed unconstitutional in Bakke. O'Connor gives the plan a pass on the least restrictive means test because other ways of granting admissions, such as a lottery or less focus on GPA and LSATs, would sacrifice other forms of diversity or greatly change the institution that UMichigan was at that time. However, O'Connor notes that the court expects that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. Thus, strict scrutiny applied again in the year 2028 would likely find that programs such as these would be unconstitutional. Justice Rehnquist's dissent can be summed up by noting that the school's demographics are not representative of their supposedly desired critical mass. There are about 1/6 the number of Native Americans as blacks, and about 1/2 the number of Hispanics as blacks, admitted from 1995 to 2000. Rehnquist asserts that one would think that a number of the same order of magnitude would be necessary to accomplish the same purpose for Hispanics and Native Americans as it was necessary to accomplish it for blacks. The court ruled in Gratz v. Bollinger that UMichigan's undergraduate admissions policy, a completely different program, was using a de facto quota system by granting 20 points for being a minority, with 100 points guaranteeing admission. The court cited that this did not provide individualized attention to each applicant, but rather viewed minorities as a group. Decided in 2013, Fisher v. University of Texas is the first major examination of affirmative action since the Grutter-Gratz decisions. It involved Abigail Fisher, a white Texas resident who was rejected from the University of Texas at Austin and who brought suit alleging that she was discriminated against under the affirmative action policy. The decision did not relook at the constitutional determinations made in Grutter, but used the findings in the Bakke and Grutter cases, adding that the burden of proving that the university's plan is indeed narrowly tailored is left to the university. The decision further emphasized the fact that there must be no workable race-neutral alternatives in order for the use of affirmative action to be constitutional. This is a much stronger emphasis on the least restrictive means part of the strict scrutiny test. Thus, the decision more clearly restricted but by no means ended the practice of affirmative action. Following Grutter Gratz, the state of Michigan banned affirmative action in public colleges and universities on a referendum with 57.8% of the vote. In the Shute decision, which was just announced on April 22, 2014, the Supreme Court voted 6-2 to uphold the provision's constitutionality. Justice Kagan, one of the 4 liberal justices, recused herself from the case because of a conflict of interest, likely arising from the fact that she dealt with the case as Solicitor General. The actual breakdown of opinions in the case is rather complicated, but Justice Kennedy, in the opinion of the court, wrote that this case is not about how the debate over racial preferences should be resolved. It is about who may resolve it. Because of the fact that no majority could agree on the legal reasoning, no precedent is set, and a future court is not bound to the decision. However, other states will likely join Michigan and the 7 other states that have banned affirmative action in college admissions. We believe that the Michigan Law School's admission system should have been deemed unconstitutional and that the consideration of race in general in state institutions ought to have been deemed as such. There does not exist the necessary compelling governmental interest for affirmative action to pass the compelling interest test. The underlying problem with the majority opinion was its failure to properly establish how there is a compelling governmental interest in offering a marginally superior education, which is what Justice Thomas deduces is the true benefit of the program. After all, there is no pressing public necessity in maintaining a public law school at all, and it follows, certainly not an elite law school. So even if it were imperative for the school to discriminate in order to exist at all, there would still be no compelling governmental interest. After all, the states of Alaska, Delaware, Massachusetts, New Hampshire, and Rhode Island do not have ABA-accredited public law schools. Turning to public school admissions in general, providing a marginally superior education is not so crucially important that it justifies racial discrimination, especially given the fact that providing a marginally superior education can be accomplished by private institutions. Thus, the interest must not be compelling of private institutions as a whole, and affirmative action fails strict scrutiny. The Grutter decision has certainly had a large effect on society as a whole and our age group in particular. First and foremost, the use of affirmative action will greatly affect who is accepted and who is rejected at some of the country's most prestigious universities. Given the fact that admissions to these prestigious institutions is the first step on a fast track to success, acceptance or rejection plays a large role in determining the degree of success of an individual. Thus, affirmative action can leave a person's future hanging in the balance. Additionally, Grutter changed the accepted purpose of affirmative action from a focus on correcting former discrimination to a focus on accomplishing diversity. Grutter's allowing of race to be used as a plus factor in admissions has also had some important effects. It has increased the proportion of minorities at the top-tier schools, which reduces all the aforementioned benefits of diversity. In doing so, however, doubt has been cast upon the ability of all minorities to succeed at these schools. Additionally, affirmative action has led to consistent mismatching, meaning that less able minorities must compete with the most able non-minorities. Thus, the non-minorities consistently perform better than the minorities. This mismatching would occur at all levels of universities, since minorities who belong to a lower level are always bumped up a level. It is near certain that affirmative action will be relooked at some point. Justice O'Connor's specified time of 25 years likely means that the Grutter decision as a whole will be re-examined around the year 2028. There is little to no way that affirmative action in college admissions in general will escape re-examination when that time comes. Whether or not Grutter will be overturned when that time comes remains to be determined, however. As noted by Justice Ginsburg in her concurring opinion, one may hope, but not formally forecast, that over the next generation span, progress toward non-discrimination and genuinely equal opportunity will make it safe to sunset affirmative action. In other words, it is no guarantee that the 25-year time frame set by Justice O'Connor will come to fruition.